Good morning. When the partner is away, the young associate will play, right? Morning, everyone. Freedom lover, Luttrell. Nice to see you all, guys. Give a few more seconds here for people to file in. Norm won't watch this playback. He'll tell me he will. Actually, he won't. He won't even. He'll put on no airs. But if he did, he would realize that, maybe a more patient approach. Slide in. Good morning, everyone. It's me again. Jackson, good morning. Freedom lover over on Rumble. Good morning to all of you. If you're doing well on this hump day. Today we've got we're going to try something new. I think we told everyone yesterday and perhaps the day before that Norm would be traveling in the latter part of this week. So the idea was necessarily to have a co-host or three come through Wednesday, Thursday, Friday. However, yesterday there was something interesting that occurred, and Norm wanted to talk specifically about with me. So what we are going to do is play a video. You should see that right there on the screen, and I'll make that bigger for everyone. And I've also had the opportunity doing this to reconfigure some of the soundboard stuff. So now I won't be shoving my mic over my speaker and then bringing it back up. This should be a little more seamless. I'll put that up there. What we're going to do is we're going to discuss Alex Jones and the Fulton County District Attorney Fani Willis's intent to compel him to testify in the criminal prosecution against President Donald J. Trump. And in particular, Norm is going to talk to our audience, all of you, about the Fifth Amendment right against self-incrimination. If you plead the Fifth, what does that mean? And in the context of the criminal prosecution going on in Georgia, what does it mean for Alex Jones to refuse to do anything, right? If he even takes the stand. He doesn't intend to take the stand, but if he does, what does that mean? And what is the underlying cause of action? What is the underlying legal theory that supports that cause of action? And how is the substance of witness testimony within the criminal prosecution relevant to a determination from an attorney's perspective, i.e. Norm Pattis, to advising the client on what he or she should or should not do when subpoenaed or moved by a prosecutor to give testimony at a trial. So without further ado, some further ado, one moment. This is all supported by an article on Politico, Alex Jones to fight Georgia prosecutors' bid to call him as witness in trial of Trump co-defendants. I will put that on the screen after Norm spends about 10 minutes here. It's about 10 and a half minutes. I'm not going to go away. I'll just kind of minimize myself. And we'll spend about 10 minutes. You'll listen to him discuss this issue. I will put the Politico article up on the screen once that is over. And once that has happened, if there's any good, I can stop intermittently throughout that video as well. So if there are questions in the chat or I feel like I need to edify something or further expand on a concept or question that I have, I'll do that. But I'll try not to extend it too long. But at the end of that, my intent is to sort of open this up to Q&A. And in the transition between this topic and the next, I will be discussing news out of North Carolina related to beverage alcohol law and what North Carolina has under its constitution known as the fruits of their labor clause, or the right to earn a living under the Constitution. And within the context of our current lame duck Governor Roy Cooper, his moves during COVID to shut down the bar industry completely, and the corresponding or subsequent lawsuit that was launched by a group of bar owners here in North Carolina, and the issue that is now being petitioned by the defendant, state of North Carolina, Governor Cooper, to the Supreme Court to resolve. This is relevant because of the Emergency Management Act under North Carolina law that purportedly authorized the numerous executive orders that Governor Roy Cooper issued during the COVID era, during the lockdown era, in conjunction with the very reliable, very data-driven, and scientifically backed opinions of one Dr. Mandy Cohen, who at the time was relegated only to the state of North Carolina to enact her well-researched policy objectives. Now she has since joined the CDC. But this originates from that era. I practice in the beverage alcohol realm. And because of that, I think it's highly relevant that we discuss it here. I have a unique perspective on certain other facts and circumstances surrounding that we may get into. And I'm just going to introduce it because I do think that the substantive due process claims and the fruits of their labor claims that are preserved under the existing lawsuit are things that Norm will have a very insightful perspective on, but at least I can lay the groundwork for when we return and we can cover this case again. Let me see what we've got in the chat here a little bit. Freedom Lover, this is going to be good. Yeah, I agree. I think it's going to be nice. I've even figured out a way to get the live stream chat over on Rumble incorporated here into the StreamYard studio that broadcasts to X, to YouTube Live, and to Rumble. So again, welcome everyone. I'm going to switch the orientation here to Norm. Here's our boy. So good morning from Norm. I'm going to step back a little bit, and like I said, if I feel like I've got something worthwhile or valuable to add, we'll do that. I'll put the banner up here so at least everybody can kind of have some idea as to the nature of what's being discussed. Had to edit the video quickly this morning. My apologies for some sort of weird editing. If you see some writing at the bottom of Norm's screen, you're not really missing anything. That was just me being an adult and doing a little much while we were recording. Anyway, without further ado, here we go. Here's Norm Pattis.
Not if you're Fani Willis, not if you want to ride your fantasies into. So if you're looking at this morning's papers, you're thinking, wait a minute, haven't I heard enough about Alex Jones? And isn't January 6th the oldest one-trick pony in the zoo or in the corral? Not if you're Fani Willis, not if you want to ride your fantasies into fame and fortune. The first of her R.I.C.O trials in Georgia is set to begin later this month, I think October 23rd, if I'm correct. And she sent the word out. She wants Alex Jones to testify. I got a call last Friday afternoon from a very polite young, well, I don't know if he's young, a very polite fellow in her office. By my contrast, if you're alive, you're young. You know, when you get to a certain age where it's all behind you and it's just nothing but the great beyond. But in any case, he calls and he says, we're going to be looking for Alex Jones to testify. And I'm like, well, you can look all you want. He's not gonna. We're going to be seeking a subpoena for him, and we're going to want him to come to Georgia to testify. I said, he'll do for you precisely what he did for the House January 6th committee, and that is he'll plead the Fifth Amendment. It's inconceivable to me that any lawyer in his right mind would let Mr. Jones testify while there are ongoing investigations, criminal investigations to this very day about the events that took place on Capitol grounds on January 6, 2020. Well, they want him there. And so I thought it would be interesting to explain a little bit about the mechanics of pleading the Fifth and how it's applicable in the Alex Jones case. First, there was no plan. There was no conspiracy. There was no overarching effort by the White House or anyone else to subvert democracy and threaten and imperil our democratic institutions. What there was a president and an administration and millions of followers who didn't think the election in 2020 smelled right. Donald Trump claimed fraud, systemic fraud. He encouraged people, stop the steal. There were a series of rallies in the fall and into January. And on January 6th, the day electoral votes were to be certified, there was a riot. And some of that riot was violent. And certainly it was disruptive. Did it threaten our democratic institutions? If you're a Republican speechwriter, it did. Or if you're working in the office of Merrick Garland and you haven't had quite enough oxygen in your hair for a while, it did. But what really happened is folks stormed the Capitol. Some of them were shouting incendiary rhetoric. Nothing got burned down. They didn't kill anyone. A few people did die. A woman was trampled to death in a tunnel. A woman was shot to death by a law enforcement officer. Some of the law enforcement officers later committed suicide. And I think one did have some injuries. But, the claim that you hear on the air, 5 officers died, as a result of this, that again is overheated rhetoric. No one talks about the woman trampled to death in the tunnel. No one talks about the number of people who were beaten by police officers. That doesn't fit the narrative. In any case, the narrative that federal prosecutors and Fani Willis seems to want to create is that this was a coordinated effort, either a criminal conspiracy of one sort or another, if you're a federal prosecutor, or if you're Fani Willis, a R.I.C.O, a Racketeering Influenced and Corrupt Organization Act. R.I.C.O is a feature of our law that says when a group of people who are working together, associated in fact, if not part of a formal organization, when a number of people associated in fact agree to commit some criminal objective and they engage in predicate acts of violating the law, fraud, wire fraud, this kind of thing. If there are a sufficient number of criminal acts or predicate criminal acts, then it constitutes a R.I.C.O offense. So Fani Willis has taken it in her mind that Donald Trump and 18 others were in association, in fact, who wanted to subvert the election, wanted to overturn the election by unlawful means. And so she's going to have to prove these unlawful predicates. And in a courtroom, you don't prove things with accusations. You prove them with evidence. You prove them with witnesses. So she wants to show relationships between the individuals that she has charged and other people who were involved in the events on the ground that day. The first trial of the 19, she's charged 19 people in Georgia. The first trial will take place, or begin at least, to take place later this month in Fulton County, Georgia. And it involves Sidney Powell and Kenneth Chesebro. Chesebro was a lawyer for Donald Trump. Sidney Powell was a lawyer, maybe for Donald Trump, maybe not. It depends on the day, as I recall the events of the fall of 2020. But they will be the first 2 defendants to stand trial. It is the state of Georgia's burden of proving its case. If it can, it does so through witnesses. Enter Alex Jones. Alex Jones was present on Capitol grounds that day. He was a visible presence. He had a megaphone. He was shouting 1776 and other words that got people prosecuted in the J6 context. As the events unfolded, however, he was videotaped on the steps of the Capitol urging people to stand down, to go away, not to engage in violence, because that is what the left would want. They would demonize the participants and make this into a wedge device to stifle dissent. And you know what? Alex Jones was right. That's precisely what did happen. Alex Jones has not been prosecuted by the feds. Early in 2021, or maybe mid-2021, when the House January 6th committee was investigating things, they wanted Alex to testify. Alex doesn't trust the government. Alex doesn't believe the government tells the truth. Gee, can you blame him? So I was his lawyer in those negotiations, and we told the committee that he intended to plead the fifth. Jamie Rankin of the committee said he couldn't plead the fifth; that would be invalid. I asked to speak to Jamie Rankin to readjust his understanding of the law, notwithstanding his position as one of the editors of the Harvard Law Review and a law professor, and the distinguished member of Congress. He clearly doesn't understand the mechanics of the Fifth Amendment. But nobody got me in touch with Jamie. The committee also demanded that Alex turn over certain records of his communications with others. And we tried to negotiate. We said, we'll give you what you want. There's nothing there. But we're not going to do so unless you grant immunity. And they wouldn't confer immunity. So when push came to shove, we did what you should do when you receive a subpoena. We didn't ignore it, as Tim Bannon did. We appeared, but Alex pled the fifth more than 100 times in response to questions. And the Fifth Amendment gives a person a right not to testify if what they say could, in the eyes of a prosecutor, tend to incriminate him. And because prosecutors, including Fani Willis and federal prosecutors, believe crimes were committed on a vast scale on January 6, 2021, and associations with those involved could be circumstantial evidence of communication and of involvement, there's just no way that any good lawyer would permit a client to testify when prosecutors are sweeping with such a broad net. Jones pled the fifth before the J6 committee, and we refused to turn over documents under the so-called act of production doctrine. The act of selecting doctrines of documents to produce in response could reflect things about our client's state of mind, and our position is the government wasn't entitled to it. Last week, we received Mr. Jones was subpoenaed by people in a civil case involving officers against Trump and others. Had the same discussion with them. Mr. Jones is not going to testify. He's not going to give you anything. We're going to assert a Fifth Amendment privilege. Now, the thing that interested me in the Fani Willis case, however, is these are presumably experienced prosecutors, and they should know that an evocation of the fifth is going to make Jones' testimony unavailable. But the office suggested they wanted Jones to come in to personally evoke the fifth, which, our view is tantamount to harassment. If he's going to assert the fifth, they don't need to bring him into Fulton County unless they're doing so to showboat. And they tipped their hand by suggesting that he might be compelled to assert the Fifth Amendment privilege in the presence of the jury. I don't know how they do that in how things work in Georgia, but in a typical criminal case, witnesses are not permitted to assert their Fifth Amendment privilege in the presence of a jury because it leads a jury to speculate about why they're pleading the fifth. You come home late from dinner tonight, for dinner tonight, and your wife says, "Where were you?" "I plead the fifth." In common parlance, that means you're guilty of something. And then your wife has the opportunity to decide what you're guilty of. Must be that other woman. Must be this. Must be that. It might not be any of that. It might just be a prudential move to prohibit a person looking at you from drawing inferences on your right to remain silent. So we have, as I said to Politico yesterday, I got a call about this. We're not going to fan Fani's fantasies by bringing Alex Jones down for her to feed him peanuts in front of a Fulton County circus. We intend to fight the
Fani's fantasies. What a poet. Sorry. We'll keep going.
The subpoena. The fight will begin first in Travis County, where they seek to get a Travis County judge to assist them in compelling Alex to attend. If we can't win it there, then we'll travel to Atlanta. And I'm telling you, Fani, here's what you're going to hear from Alex Jones. Got your pencil handy? On the advice of my lawyer, I assert my Fifth Amendment privilege. As many times as you ask a question, you're going to get that answer. So why not save taxpayers some money? Why not put the makeup aside? Why not focus on the case you can prove rather than the case you wish you had and the television cameras before which you want to posture? Case closed. Alex Jones isn't testifying.
Well, look, I was bragging about myself and then didn't have the wherewithal to turn my own volume back up. So short and sweet ending there. The point is, Alex Jones does not intend to testify. So whether the court so moves and grants or Fani's fantasies, so to speak, whether that happens or not, he will still take the fifth and he will remain silent as to any of the underlying efforts. I think one thing that I want him when he gets back, and perhaps maybe he can call in tomorrow and talk a little more if we can, if he's up early enough, I can just have him, call me and we'll do sort of a Norm chat line kind of thing. I'd like for him to talk more about the, I think it's the 19 individuals named within that lawsuit that are alleged to be involved in conspiracy and R.I.C.O related activity. And that is a massive, just in terms of a complex network of interactions between all of those. My mind sort of boggles trying to connect the yarn from one side of the corkboard to the other between them. But that's exactly the reason that one such as Jones would not. I think practically speaking, if you're Norm, you're looking at this situation and you're acknowledging that there's no reason for Jones to subject himself not only to the known risk of incriminating himself, whether there's anything legitimately there or not, but that he is putting words on the record. But then also the fact that there is no way to adequately predict how certain of these yarn strings that I referenced are connected on that cork board, the government cork board, on the other side of that sort of opaque wall. That is their trial strategy. So we don't want to think that that is as sinister as this is, but I don't know that we're under any illusion at this point. So anyway, like I think I promised that I would put the Politico article up. Let me reframe here. And let me check the chat here. What are you guys talking about? Yeah. Yeah, I bet the InfoWars store is selling quite a lot of vitamins. And there we go. We're going to pull up the Politico article. Here it is. So this is just a look at what I was referencing earlier. This is where Norm is quoted, so I will read again where he's quoted. But the title of the article is Alex Jones to fight Georgia prosecutors' bid to call him as a witness in trial of Trump's co-defendants. Fulton County DA Fani Willis indicated that she intends to compel the testimony of the far-right broadcasters. So love that, Politico. Way to go with the far-right designation. Quote, Alex Jones intends to resist efforts by Fulton County District Attorney Fani Willis to compel him to testify in this month's trial of two Donald Trump co-defendants, his attorney said Tuesday. Norm Pattis, an attorney for the far-right broadcaster, said Jones has nothing to offer in the trial, and that even if a court were to order him to testify, he would simply plead the fifth, as he did when subpoenaed to testify to the House January 6th Select Committee last year. Quote, we're not going to help Fani's fantasy life come true any more than we did that of the January 6th committee, Pattis said. So he's not going to fan Fani's fantasies. Any questions that we have for Norm, feel free to throw those in the chat, and I will make sure to get those over to. But I thought it was important this morning to at least get Norm talking about this, and he certainly did. He was willing to get up and be online around 6:15 with me to record that for you all. So, I'm taking all the producer credit for the vintage look on that on the video, and I appreciate all of you. We are going to transition in a second here to the Q&A, but as promised, in between time, I wanted to pull up something else, and this comes directly from my world. I'm going to share the Carolina Journal from October 5th. And this is important. And this is important for a number of reasons. The title of this article is Bar Owners Oppose Cooper's Appeal in COVID Shutdown Suit. I've talked before a little bit about the three-tier system for alcohol regulation. So the business of alcohol is regulated along three tiers, and that is every state after the ratification of the 21st Amendment was allowed by federal law to regulate the manufacture, distribution, retail sales, transport, export, import, etc., as it saw fit. And the model that developed on the back of that was known as the three-tier system, which separates producers of alcohol from the wholesale distribution network that then puts that product into the retail market. So wherever you find, if you do drink, you can find beer, wine, and just depending on the state, spirituous liquor in your grocery stores or in your ABC stores. You can order beer, wine, spirituous liquor in restaurants or at bars. There are some movie theaters that do that, but my practice focuses on that overlay, that administrative and regulatory framework that controls and regulates the commerce involving alcohol. And that is how I have come to understand business more broadly, is understanding that network. In a place like North Carolina, it's called a control state for spirituous liquor. So think your gins, your vodkas, your rums, your bourbons, your whiskeys. And those spirits it's called a control state because the state has a monopoly on the distribution of those spirits. In other words, any spirit, whether it's produced within the state or from outside of the state, must come to rest at a state-controlled warehouse facility. The main one of which is in Raleigh, North Carolina, where the ABC Commission is located. And from there, there's a network of ABC stores. That is, each county elects over the course of time to create an ABC store, and that ABC store has its own board. And those boards oversee the purchase of products within the framework of the control state, meaning that if you are an individual consumer, you may only purchase spirituous liquor in two methods, right? If you would like to have your own bottle of that, you must go to an ABC store to get it. You're not going to find it in North Carolina. You're not going to find it in the grocery store. You can't buy a bottle for yourself in a restaurant. Or you are consuming pursuant to what's known as a mixed beverage permit, right? That is that a restaurant owner or a bar owner may serve you by the drink, but they may not do anything other than that. So a shot, a mixed drink, whatever it is, they may do that with spirituous liquor. And they, too, must purchase their inventory of spirituous liquor from those ABC stores that I just referenced. So you can understand that this framework is rigid with respect to beverage alcohol regulation, and wherever a consumer engages with the purchase of alcohol, that is known as a retail sale, right? That is the retail segment. So the retail segment is most tightly controlled, right? How a product makes it into a customer's hands, and there's good reason for that, right? We want to curb underage drinking. We want to curb overconsumption. There are certain public policy objectives that aren't debatable. However, during COVID, and let me go back again. One must understand that if the ABC stores are the only way to get spirituous liquor, that is also to say that the highest value alcoholic beverage products are controlled by the state, meaning that the revenue is generated through state-controlled local boards, right, and local ABC stores exclusively, right? So where a producer might sell certain amounts of product into a warehouse, they're still selling those products at a wholesale value, but the retail value is set by the state, and it is purchased by those who walk into ABC stores or purchase it through restaurants and bars with the markup that those individual restaurants and bars need to put on top of it. But by and large, we're looking at a segment of the population that relies heavily on alcohol for their business models. And what's occurred in the last several years, and I know I'm wandering and rambling here, what's occurred in the last several years, from my vantage and that of my law partner and several other of my colleagues that practice in this area around the state, there are very few of us, but we're way more fun than the average attorney. What's occurred in the last several years on the back of COVID is a very, very top-heavy, coercive executive push on this sector that started with the executive orders and the appeal to the Emergency Powers Act under North Carolina law that allows the governor, because the ABC Commission, which is a creation of our Congress and has jurisdiction of everything alcohol, because that is a division of public safety, i.e. answerable to the executive branch, the governor, a division of law enforcement, in other words. Because of that, he had, and I say he, Governor Roy Cooper, had complete autonomy over the regulation of those businesses, as he purported to do with every other business, but most directly because the authorizations to manufacture, sell, purchase and sell at wholesale, and to purchase and sell at retail, because all of that is authorized by and through a series of permits through the ABC, which is answerable directly to the governor, there is a very tight grip on his ability to control that. And so there's a lawsuit launched by a group of bar owners that is going forward. They have sued the state of North Carolina, Governor Roy Cooper, I think Phil Berger, and another senator as well, pursuant to their regulation of, or really their closure of bars during COVID. So as compared to breweries, as opposed to restaurants, as opposed to other varieties of retail outlets, bars, exclusively those segments of the population of businesses that did not offer food, right? AKA didn't have a health department inspected kitchen or weren't otherwise regarded as some sort of private club, which I'm not going to go down that rabbit hole. The state saw fit to say that, yeah, bars should close. Period. They should close. You guys should close. You shouldn't be allowed to operate because of COVID. And many bars were gone because of that. Some fought vigorously to get a private club designation. Others fought vigorously to become restaurants. But by and large, you had a segment of the population that it was highly vulnerable, and you can understand the damage there. So this lawsuit is going forward on well, it alleged three causes of action. One was a violation of equal protection. One was a violation of substantive due process. And the other was a violation of what North Carolina calls its right to earn a living clause under its constitution. What you've heard me recall is the fruits of their labor clause. I'm really heartened by what I'm seeing in this lawsuit. You know, the appeals court in North Carolina ruled in favor of the bars on two of those three items. Equal protection was thrown out, but this lawsuit is surviving on a violation of substantive due process and a violation of the right to earn a living clause under the Constitution. Norm has talked before about sovereign immunity and the protection against monetary damages from the state for acts taken in furtherance of the state objective. But this lawsuit is really important because it is laying the groundwork for piercing that veil of qualified immunity, piercing that liability shield that exists around what has really just been an unfettered executive branch here in North Carolina with respect to the beverage alcohol industry. So I wanted to highlight this. We'll talk more about it, but if you're in North Carolina, look at the Carolina Journal article on this, and I'm happy to talk more about that. But I'm going to open up for Q&A. I went over time a little bit here, but we'll do about 10 or 12 minutes here. We'll try to end at 8:45. Let's see. We got quite a few people here on Rumble as well. Let me see if I can pop out the chat, and I'll throw it in here as well. There we go. All right, here we come. Sorry, everyone. Look at y'all. All right, over on YouTube, got several comments coming in over here. Are Norm's longtime acquaintances treating him any differently since he represents far right, quote unquote, Alex Jones? I don't know. But I also don't know that the question is necessarily relevant to Norm's disposition, his natural way of engaging with the world. I think anyone that meets and knows Norm understands that he is the proverbial lone wolf. I think that's something I respect very much about him is his sense of independence, and that lives very deep. So he's talked before that he and his wife politically are on opposite ends of the spectrum, and at least currently. We've talked before about the Overton window shifting, but I don't know that his longtime acquaintances or longtime friends or even longtime loved ones would treat him any differently for representing Alex Jones, or even if it was someone like Louis Farrakhan, right? I think that the nature of Norm is that he does not require your consent to stay dedicated and stay devoted to those Western ideals, those principles of our republic, right? Those fundamental rights of free speech, freedom of association, freedom of the press, the Second Amendment, the right to privacy, as culled down from the Fourth Amendment, especially when it comes to litigation, criminal litigation, the Fifth and Sixth Amendment, these things. Norm was norm before Alex Jones was persona non grata, right? Norm was ponytail Norm doing his thing, pioneering the next iteration of 1983 litigation when it was necessary and when it was widely unpopular. And I think that the answer to your question, thus, Freedom Lover, is no. Mike, roughly how many states have a monopoly of distribution, such as North Carolina? Fewer and fewer. Off the top of my head, I can't really remember the total number, but I know Virginia to our north is a control state. I believe South Carolina to our south is also a control state, but states like Florida are not. States like California are not. And I think that there is some. Here's what I'll say, severe conservative. The sort of liberal to conservative political paradigm or spectrum is easily seen policy-wise through a state's approach to alcohol regulation. And what Pennsylvania is a great one. Yeah, severe conservative says Pennsylvania, yes. Yeah, I don't totally understand Pennsylvania's laws. I've heard quite a lot, and I've read various things coming out of there, but I've heard before that you have to actually go to a distributor to buy cases of beer and stuff like that. That, to me, when you say distributor, I would have to go to a massive warehouse, and maybe indeed that's what it means. But anyway, the political paradigm, as seen through the lens of beverage alcohol regulation, is really instructive, in my opinion. States like Washington and Oregon, for example, I talked about the 3-tier system. States like Washington and Oregon have all but collapsed that 3-tier system, right? Such that distributors, as they sit here in North Carolina, there's what's known as franchise law. Franchise law affords an independent wholesale distributor of beverage alcohol in North Carolina the exclusivity as to brands it carries and the geographical territory that it services. So in other words, if I'm a producer of alcohol, let's say beer, for example, and I want my products to be distributed in the Piedmont of North Carolina, so that middle section of counties within the state, and I go to a distributor and I sign those, we sign a distribution agreement. That distributor would have all of my brands indefinitely for forever. And it would not have to compete with any other distributor in that geographical territory to bring those products into retail accounts in that geographic area, meaning that I could not sign another distribution agreement with a different distributor over the same territory. And it sounds really, restrictive, which I think it's designed to be that way. But one must also have a perspective on the beverage alcohol industry that extends before there were 10,000 plus breweries in the country, before we had this proliferation of local and craft and whatnot. The system was designed to preclude states from, or big suppliers, big manufacturers of alcohol, from being able to monopolize the industry, to monopolize points of distribution, to squeeze out competitors, to force price down at the point of sale, because as a public policy objective, you saw more underage consumption, overconsumption, prostitution, gambling, drug use, when alcohol was cheap. So the number of states that have a monopoly over distribution will reflect some level of conservative values. That's what I'll say. Sorry for the long answer. Don says, is it true that Congress people can defame and slander people in the Capitol and be immune from defamation suits due to immunity? If so, that stinks. I think it's on the floor, right? So those remarks made on the floor of Congress are immune from legal scrutiny under the First Amendment, or the exceptions to the First Amendment. And I think that's for good reason. But in today's day and age, I certainly agree that it, quote unquote, stinks, mostly because of how viral the clips are that come off of C-SPAN and stuff like that, right? And the average civilian in America does not know the answer to the question that you just asked, Don. And Norm would certainly have, I think, more to say about that. Let me go over to the to Rumble. Critical Thought asks, Florida to North Carolina here, not entirely by choice. It was a hard transition. Roy Cooper has deep ties to big pharma, big agra, chem, big tobacco, which I love. He has run the economy and morale into the ground. Happy to see him get raked over the coals. Yeah, so nice to know that you're a fellow North Carolinian there, Critical Thought. I certainly have my perspective on Governor Roy Cooper. I call him Nerd Neck, and I think that he is a huge coward. I think that he represents everything wrong with modern politics in that he is very soft-spoken. He is a chameleon with respect to the moment, the political moment. There are no obvious commitments other than those that we saw during the pandemic, during the COVID era lockdowns, wherein he decided that whichever way the wind was blowing, that was the direction that he was going to take our state politically. It's obvious to me that the current state attorney general is also running to replace him is the exact same guy, just a different person, but same politics. This is the same guy that we've covered before, the current attorney general, Josh Stein. The same guy that decided that he was not going to do his job and enforce the law as passed by Congress with respect to Congress's abortion scheme, and came out sort of using that as a campaign. North Carolina is a purple state. It's been a purple state my entire life. So you can find a little bit of whatever you'd like here, I think, which makes us great. I think North Carolina is the center of the known universe. But Critical, you bring up a few interesting things, right? Big pharma that's true. I remember traveling, because I'm from the Johnston County area, traveling east, you pass big Bayer plants and stuff like that. Big tobacco, obviously Brightleaf tobacco was originated here in North Carolina. Bull Durham, the movie, you can see the facade of the city there. That's Lucky Strike brand was born in Durham. R.J. Reynolds, which is now Reynolds American, but that's all of Winston-Salem, Winston cigarettes. So there is a lot of industry that shaped and influenced our culture that originates here, including the big Jordan symbol, right? So the Chapel Hill is now synonymous with sort of Michael Jordan, and they've really used that as almost sort of as an immunity against criticism for the stuff that they're doing. The University of Chapel Hill, that is. Anyway, let's see, what else do we have? Speech and debate clause. Yes, severe conservative, going back to the floor of Congress. He's a typical establishment. Yep. Don, I agree. You can support Norm through the Owen Schroyer Legal Fund on Gibson Go. Yes, you can. And he's posted quite a lot about that on his X account at Pattis Norm, and we retweet it through at LawPod Daily. I do love Johnston County. Well, you said Johnson. I'll forgive you for leaving out the T. That's the real deal. The middle of the state is generally a cesspool. Yeah. Let's see. All right. Well, not too many comments here, but we're going to end the live stream. I wanted to at least, try out a couple new things here from the tech side, which it appears everything is working. It's always easier when we've got Norm running his mouth, right? You don't see me kind of, trying to work around, but we'll get it right. I do appreciate everybody being here. Anything else before we get out of here? I think one question I want to ask is what sorts of, what can we do better for you? I know that I don't want you to hear what I'm not asking, which is we are already here at 8 a.m. every Monday through Friday, unless I go on vacation, in which case Norm can't do the whole analog thing that I do with the tech. But we'll get him there a little bit. But what are we not doing for you that you'd like to see, and sort of make it easy? If you have anything low hanging, you can always suggest those things. You can always send an email to pattispodcast@gmail.com. My commitment to everyone is to getting some sort of small website set up here soon. I know Pete Atkinson has been a huge proponent of encouraging us to actually independently network our following. And I agree. There's only so many hours in the day. So, so aside from low level stuff like that, just, a lawpoddaily.com with an email sign up, those sorts of things. But, we're trying to explore stuff. I don't know about putting stuff behind a paywall. I'm not trying to insult anybody with that kind of stuff, but additional content, easy content, guests that you'd like to see on here, those sorts of things. What do we have here? Friday hour-long streams again. That was nice, right? And I think that we kind of naturally do that on Fridays, but it's driven a lot by you all, if I'm honest. When we get on here and we go for longer, it's because there are typically the topics that we're getting at are maybe a little more interesting, but I think that that's just more of a function of how active our chats are, right? I would like to see a legal perspective on best states to live in, freedom scale. North Carolina is the only one on that list. I'm just kidding. No, I'm not. Big thanks to you and Norm for today's show. Very well done. Share this everywhere, peeps. Yes, please, Justin, and always great to see you, man. I know you've got your own life. So thank you for your support over on X. You deserve a big credit. I feel like there's several people that watch us every day that are they're religious about making sure that they share our streams, whether it's on X or on YouTube or on Rumble. Thank you all. I see all that stuff. I don't always have time to send you a note. And if I could make that time, I would, but it means a tremendous amount to us. And it means a tremendous amount to me as just sort of a young guy trying to soak up as much as he can from someone like Norm. So have a meetup at Norm's bookstore. That would be a cool live event, would it not? How many people would travel to like rural Vermont or Connecticut to do a bookstore? I'm just kidding. But we could do something like that. I've toyed with it as well. I think that's it for. Would you ever change the hours you live broadcast? Sure, later in the day would be more popular. T-Girl, I don't know. That's a great question. There's a couple of reasons that I'll share this with you. A couple of reasons that we actually went for the earlier time slot, and that is because less competition within those other later hours. It's not lost on me that there are other just mainstream popularity. I don't mean to say that they're mainstream and that they're establishment, but I'm speaking specifically about the Viva Frey, the Tim Pool and Timcast IRL. These are shows that have scaled way beyond my comprehension, right, and my know-how. But I think that what Norm and I wanted to do was to make sure that we weren't really trying to be seen as competing within what they do. I think that Norm and I do something distinct from both of those shows. It is tough for me to reconcile how we get at legal concepts topically, other than following what is somewhat current in the news. That's the easiest way for us to sort of get at those more ethereal legal concepts or theoretical concepts or things that just live on paper, and apply them to something that might help people really engage with that content without getting at a topic area that already is interesting to them by virtue of what they're following. And to some extent, we overlap with those guys already. So putting it earlier does two things. It allows everybody, if you like to join us live or all of those shows live, that we're not really competing in that time slot, but also it precludes us from really, because if we do it early in the day, we are looking at stuff from a fresh perspective. At least I am, in terms of what things I like to curate for the audience and how to best highlight Norm's skill set and knowledge area. So that we're not seen as sort of like taking from these other shows in terms of what's popular or what everybody else is talking about. It gives us sort of that ability to have blinders on if we're early in the morning. Now, having said that, I think that if we ever did move it, it would be as a supplemental move, right? So if we're doing it 5 days a week or even something less, and we did push a show into the latter hours of the day, that would just be because maybe that as a product is different from what we would do on the morning streams. So that, I hope that answers your question. Start earlier, run longer. Man, Jackson, good Lord. Yeah, T-Girl says right after that, you also have legal careers. Those other pods are their sole employment. Don't get me wrong. I'm trying to retire Norm. So if there's a way that we can monetize this and we can get him into a position of not having to sell his time by the hour as a 68-year-old grandfather, and I don't know that he needs to write anything else on his resume, right? I think he's proven what needs to be proven for his personal life. I would love to get this to be his full-time thing, just transparently. No, we need to keep Norm in the courts. Well, look, there's younger people like me that I think Norm could do a better job of mentoring if he had more time to be outside of the court himself. I hope that makes sense. It's really important that we not look similar to what we're looking at in Congress right now. I do urge people to look at it from that perspective. If we have problems with sort of an octogenarian class that seems sort of cloistered in our congressional seats and our executive branch and otherwise, it's incredibly important that we ask these people that have reached the heights of their career to give that back to the younger generations to ensure continuity of knowledge sets and historical memory. I think that's part of the reason that we're in the crisis that we're in right now as a system and as a country, is that the complacency that came with sort of that momentary realization of sort of a global dominance for the United States has resulted in a certain laziness or inability to appreciate the sensitivity or how fickle all of that is if we do not urge every generation to preserve it and to continue growing. So to that end, maybe that's the best value proposition I can put toward all of you, that if there is a way for us to get Norm in a financial position through what we do here to be able to act as a mentor to law students, to young people, and I begged him to do what we're doing here, right? I mean, it was several LinkedIn messages and desperate phone calls to colleagues to beg him to just answer. Just tell me no, and I'll shut up. I'll leave you alone. Just tell me no. And he didn't. But we need to bring him into a position where we can add an exponent to his impact, right? Because we're not going to have the Norm that we have now forever. You know, Alex Jones is not going to have the Norm that he has now forever. Joe Biggs and others, Owen Schroyer, they're not going to have the Norm that they have now forever. And I'm not going to have the Norm that I have now forever. So I think from that perspective, you know, whatever you guys can do, share the show, share it. Just that's all you do. We're going to show up every day, share it, and we'll keep volleying ideas. Jackson says, "Great job today, Michael. Thank you." Let's see. Has Norm ever considered commenting on major true crime cases? In what way, Lawyer Will? So Brian Koberger's among those named there. What do you? I think we comment here sometimes, but how are you saying where that comment could be found? In the Cloud says, "Do you have thoughts on a maximum threshold for cash bonds? There's an accused murderer with a $10 million cash bond right now. Do you see that as egregious and infringing on rights?" I think the question that I would answer if this were a law school exam would be, what is the difference between a judge ordering there to be no bond versus setting a bond at a number like 10 million? Functionally, they feel the same. Critical Thought says, "Oh, I was thinking of Johnson City by Boone." Johnson City is Tennessee. Yeah. But I'm very familiar with the western part of the state as well. Lawyer Will says, "Commentary on the latest things happening in true crime cases." So, yeah, Lawyer Will, I'm sorry if I'm not, sometimes I'm not clear. And Severe Conservative says the same thing. He says, Norm has commented on true crime cases. I guess I'm asking you what form that commentary would take, because it seems like we're actually we're on an idea right now, right? So this is what I was asking earlier. What can we do? I love the idea because I think that we do from time to time comment on high profile cases, but it's through buying through this stream and on a small segment within a 30 minute show. If you're saying that that commentary should be reduced to a reel or a short or some sort of separate product. I would agree. It would be a matter of executing on what that is. I'm looking to move to East Tennessee. Sounds like North Carolina side of the Smokies isn't good. In what way? It's me again. Because again, very familiar with that area. Jackson Bear said, created Nick Salmon payday for Norm. Bait car, a defamation case. I think I've got one, and it's not a defamation case, but on the topic of beverage alcohol and substantive due process and the right to earn a living. I think I've got a fact pattern and a client now that would make headlines, at least regionally. Lots of legal sites do true crime, redundant, focus on constitutional rights. I agree, Dawn. Doing what I do, and I love this because I think we are focused on the constitutional rights. So obviously, like the true crime stuff, I think I want to be careful. There are a lot of like non-lawyers in that sector, and I think that there are really popular podcasts that handle those things, but they're way overproduced, in my opinion. There isn't a whole lot of analysis and experience-driven commentary on that stuff. It really is just sort of a high production, quick cuts, chronology of events and whatever else. I think that everything that we do here with respect to analyzing any legal matter is through the lens of those, hopefully, right? Whether it's, somewhat circuitous or meandering, is focusing on those constitutional rights. So within the context of due process, right? Criminal due process, that would be why we would follow anything like Brian Koberger or whatever else. Yeah, again, that's the key. Thumbs up and share every day. It takes seconds to help pay them back. Yeah, thank you, Jeff. That's right. All right, guys, I'm looking at the clock here. It's 8:57. I'm an idiot, and to my law partner, if you're watching, I'll call you in a couple minutes. I know we got some stuff to do today. T-Girl, I've heard both Dersh and Norm admit there are districts where there is no way they can win certain cases, red versus blue. Is there any plausible way that can be fixed? Keyword there is plausible, I think, right? I don't know. Yes, I want to say yes, because I'm generally an optimistic guy, even though I'm probably the most cynical when it comes to my own endeavors. But I'm optimistic that can be changed, most certainly. But I do think it will take an awakening of sorts. It will take sort of a jogging of that historical memory that I referenced earlier on. I think that's just about it. Anything else available? Yeah, wrap it up. All right. I'm out of here. What about Norm having classes for pay on constitutional law? It's me again. We're working on that, kind of. But yes, that's the idea. Anyway, all right, guys, I'm getting out of here. I'll see y'all tomorrow.